The Family and Medical Leave Act, also known as FMLA, was enacted in 1993 to help employees balance work and family life. The FMLA requires covered employers to allow eligible employees to take unpaid, job-protected leave for qualifying reasons. Covered employers are private employers that employ 50 or more employees during each working day for 20 or more weeks in the current or previous year. Public agencies, including state, local, and federal employers, as well as local education agencies, are considered covered employers regardless of the number of employees they have. In order to qualify for FMLA leave, an employee must have worked for an employer for at least 12 months, and he or she must have worked for at least 1,250 hours during the 12-month period before leave is taken. In addition, the employee must be employed at a location where the employer has at least 50 employees within a 75-mile radius. Eligible employees may only take FMLA leave for qualifying reasons. Some qualifying reasons include the birth and care of a new child and the placement of a child with the employee for adoption or foster care. Leave can also be taken for care of an immediate family member with a serious health condition, or if an employee is unable to work because of his or her own serious health condition. A serious health condition is an illness, injury, impairment, or physical or mental condition that involves inpatient care or continuing treatment by a healthcare provider. It can also refer to a period of incapacity due to pregnancy, prenatal care, or a chronic serious health condition such as diabetes or epilepsy. Eligible employees can take up to 12 work weeks of leave during any 12-month period. In addition, employees can take up to 26 work weeks of leave during a 12-month period to care for a covered service member with a serious injury or illness. The covered service member could be the employee's spouse, child, parent, or next of kin. Employees can take FMLA leave intermittently or on a reduced leave schedule under certain circumstances. FMLA leave is typically unpaid. However, an employee may choose, or an employer may require, the substitution of paid time off to cover some or all of an employee's FMLA leave. If substituted, paid leave and FMLA leave should run concurrently. If leave is foreseeable, employees must provide at least 30 days advance notice. Otherwise, employees should notify their employer as soon as possible. During leave, employers must maintain employees' health benefits. Once employees return to work, they must be allowed to return to their original position or an equivalent position with equivalent pay, benefits, and other conditions of employment. Employers should maintain records regarding FMLA obligations, including dates of FMLA leave, employee notices, and premium payments. These records should be kept for at least 3 years. Failing to comply with the FMLA can lead to significant penalties. Employees can bring lawsuits against employers, and the Department of Labor can also bring a lawsuit on an employee's behalf. It is important to remember that state and local laws may vary. For more information on FMLA requirements, contact your broker.